Hello all. So after discussing about tort and impact of tort affecting the valuation of a property, in today's session we are going to cover law of arbitration, conciliation and also auction. So we'll talk about salient features of law arbitration and conciliation, and we will discuss about auction from IBBI examination perspective in detail. So this is the full syllabus as per IBBI exam syllabus, which carries 10 marks of theory as per existing schedule, and with effect from 1st July 2022, these topics will cover 9 marks of theory as per IBBI exam syllabus. So let us first talk about law of arbitration and conciliation from IBBI exam perspective. What is arbitration? It is a process in which a dispute is submitted to an impartial outsider who makes a decision which is usually binding on both the parties. That is nothing but an out of court settlement. Thus, it is out of court settlement of a dispute wherein decision given by or signed by an arbitrator, who is also called dispute resolution practitioner, after having arguments and evidences of both parties. Conciliation: when parties, with the assistance from a dispute resolution practitioner, the conciliator, is also called the conciliator, discuss issues to reach an agreement, which is called settlement. So let us have a comparative analysis between arbitration and conciliation, and let us understand key features. So if we talk about decision making, so in case of arbitration, arbitrator decides finally after hearing view of both parties. However, in case of conciliation, parties themselves find a solution basis assistance taken from conciliator. If we talk about precondition, in case of arbitration, the process can start if and only if there is arbitration agreement signal agreement signed between the parties under dispute. However, in case of conciliation, no such requirement of signing an agreement is required. If we talk about appointment, in case of arbitration, arbitrator can be appointed even after dispute arises. However, in case of conciliation, conciliator can be appointed only after the dispute has arisen. Now next point, number can be even or odd. So in case of arbitration, number of arbitrator must be odd only. Please note down this point. However, in case of conciliation, number of conciliator can be even or odd. In case of arbitration, decision given by the under the process is called arbitral award. However, in case of conciliation, decision is known as settlement. In case of arbitration, decision is signed by arbitral tribunal members. However, in case of conciliation, the decision or settlement is being signed by parties concerned. So next is alternative dispute resolution. It is also called as ADR. Alternative dispute resolution refers to means of settling disputes outside the courtroom. It has 4 types: negotiation, mediation, conciliation and arbitration. So negotiation is nothing but it is voluntary and there is no involvement of third party. Mediation: third party simply assist the parties to help them find a solution. Parties sign an agreement which defines the future behavior of the parties after they agree upon a solution. In case of conciliation, here also third party is involved but play more active role than mediation. At the end, the negotiated settlement is being signed by both the parties. And the fourth type of ADR is arbitration. Here, third party arbitrator or panel of arbitrator, after hearing views of both parties, pass an arbitral award which imposed on both the parties. So these are the key differences between arbitration and court proceedings. So if we talk about cost of the proceeding, so in case of arbitration matters, the cost is lower than court. However, in case of court matters, court proceedings, the cost is very high. In case of time efficiency, arbitration matters are time efficient. However, court matters are time taking process. Power with the parties: in case of arbitration process or arbitration matters, arbitrator is appointed by the parties. However, in case of court proceedings, court matters, there is no power in the hands of the arbitrator except jurisdiction. If we talk about specialization, since arbitrator is appointed by parties, they may appoint a sector specialist. This is also an important point from exam perspective. The judge may or may not have required skill, and he rely on expert view in case of court proceedings or court matters. So now let us talk about auction. What is auction? It is basically a process of buying and selling goods or services by offering them up for bid, taking bids, and then selling the item to the highest bidder. That is the definition of auction. Users involved in bidding process. So they are basically, these are the following users who are normally involved in bidding process or the auction process. So first is buyer, who is also called bidder, one who is keen to buy products for a relatively competitive price by placing multiple bids. Next user is auctioneer, one who is responsible to judge the auction or the one who takes the decision of selecting a bid. And third user is seller, who is also called admin or auction house. He or she is one who is responsible to provide and arrange an opportunity for auctioneer. So there are certain features of auction sale which from examination perspective you should know. One is advertisements, to make public aware about the auction. The advertisement should give description of goods, time, venue of auction sale, name of auctioneer, reserve price, etc. Particulars and catalogues. Sometimes auctioneer prepares some particulars and catalogues of good to be auctioned to approach prospective buyers before auction sale. Third is conduct of auction. The advertisement specifies how the auction sale will be conducted. Misdescription and misrepresentation. This is also an important point. In case of sale under misdescription or misrepresentation or mistake happens, the sale is therefore voidable by the buyer within reasonable time. Please note on this sentence, the sale is therefore voidable by buyer within reasonable time. Auction of sale in lots. Auction can be done in lots also. Each lot is subject to a separate contract. Reserve price, the price, it is a price stipulated as the lowest acceptable price acceptable by the seller. Right to bid. Person who meet the criteria prescribed by the seller or auctioneer has right to bid during the auction process. Bidding agreement, knockout. It is a situation, this is a very important slide from exam perspective. So it is a situation where intending buyer agree not to bid against each other. They connive each other with an intention to buy the goods at a cheap price and subsequently sell them through their own private auction. It is a criminal offence under English Act. Please note down this line. In such a case, the seller can rescind or cancel the sale at the auction itself. However, it doesn't apply to joint agreement to purchase goods such as joint venture. So knockout is nothing but knockout is situation where a dealer gives or receives consideration etc. for abstaining from bidding. I give you money not to bid for a particular good. That is an example of knockout. Such knockout agreements are also criminal offence. A dealer is a person who in the normal course of business attends sale by auction for the purpose of purchasing goods with a view to resell them. Please note down the exception that knockout agreement by non-dealers are not necessarily illegal. Please note down this exception from exam perspective. Memorandum of sale. It is a written document in which the auctioneer records each and every offer with regard to its sequence and timings and ultimately the final bid. This document avoids any mismanagement during auction and also helps the auctioneer to trace out the bidding agreement by buyer, if any. Next is deposit. There are two types of deposits involved in process of auction. One is earnest money deposit and other one is deposit after auction. So what does that mean? Earnest money deposit, amount that is buyer need to deposit to become eligible to bid for the property. And deposit after auction is nothing but it is successful buyer need to deposit the remaining amount within certain period to claim title of the goods sold during auction. Authority of auctioneer. So the legal position of an auctioneer is same as that of an agent. Please note down this statement. Very important from exam perspective. The auctioneer must act in good faith and in the interest of his principal. Number one. He must conduct the sale in accordance with the instruction of his principal. Number two. An auctioneer is a special agent who can take only under the authority of his or her principal. Number three. Number four is that an auctioneer cannot bind his principal beyond his actual granted authority. Moreover, an agreement or a contract which is beyond an auctioneer authority will not be binding on the principal. An auctioneer's authority ends when a sale is completed, and the purchase price is collected. So he has authority till this point. Money is collected. So these are the duties of vendor, purchase and public. Please note down, very important from exam perspective. Vendor duties are to deliver proper legal advice, number one, to deliver goods in proper condition. And in case of purchaser, the duties are adherence to conditions of auction, pay for goods purchased during auction. And in case of public, the duties are normally public has no duty, but they should follow all rules and law of land during the auction process. Statements on Rostrum. Rostrum is nothing but a raised platform. It is also called dais, on which a person stands to make public speech, receive an award, etc. So this is the definition of rostrum. Please note down. During auction, auctioneer makes certain statements from the rostrum. These statements on rostrum have legal effect and binding between the parties. Rights of auctioneer against vendor and purchaser. So, right to receive remuneration. As per section 219 of Contracts Act, an agent is entitled for remuneration. However, as per section 220 of the Contract Act, an agent, if found guilty of misconduct, has no entitlement for remuneration. Right to indemnity. The employer of the agent is bound to indemnify him against the consequences of all lawful acts done by the agent during auction process. Right to compensation. An agent is entitled to claim compensation for the injuries suffered, if any, during the auction process. So last topic is duties of auctioneer: to take care of all goods to be sold, to ensure compliance of all instructions and conditions of the sale, and third duty of auctioneer is to keep deposit received after the sale in safe custody and give money to whom it belongs to. So that's all for today's session. Thank you for watching today's small session. So before I am going to tell you what we are going to have in upcoming sessions, I would again request you to please subscribe to the channel and click on bell icon. So in upcoming session, so this part we have already covered, this law of arbitration and auction. In upcoming session, we are going to discuss about law of evidence, then by IBC, Companies Act, Companies Rule, SURFACI and Banking Regulation Act. Thank you for watching.